The first case before the court is State of Ohio versus McIntyre. You're the only one arguing. Please step forward. And as you know, you have 15 minutes, and since you're the only one arguing, I'll just give you a sign when 15 minutes is up and we'll be done.
Okay. Thank you, Your Honor. May it please the court, my name is Stephen Cannavella. I represent the appellant Louis Leroy McIntyre Jr. I need to first address the nature of this appeal. Is that, you know, this court knows this case goes back to 2009, and there were 2 prior appeals up until this point. But this operates as the first direct appeal because we now know there was an undisposed charge, which then therefore rendered the fact that the case never had a final appealable order, and therefore this court never had prior jurisdiction to hear any of the prior appeals. And so the undisposed charge was taken care of in the trial court. Judge McCarty made the right decision in deciding that there had never been a final appealable order in that case, and she declared partial mistrial. And at a subsequent hearing, the state moved to dismiss the remaining undisposed charge. Mr. McIntyre was then sentenced on the remaining 3 charges, and which he had time served, and that's from that order as to which this appeal is taken from. And so the state is now trying to shift its position and say, oh well, Judge McCarty couldn't make the declaration there had never been a final appealable order, when they pretty much had conceded that fact in the trial court. You know, by moving to dismiss the undisposed charge, they acknowledged that there was a charge that had not been disposed, and there's plenty of case law that says that when there's an undisposed charge, there's no final appealable order, no jurisdiction for the Court of Appeals. And so, and I'm sure if this court had known that, if anybody would have caught on to that, you know, back in 2009, 2010, I'm sure this court would most certainly dismiss the appeal and send it back to the trial court to make sure everything was fully resolved. But it was an error that just wasn't found until several years later.
But the case has come up on appeal a couple of times since
it has.
then, right?
There have been 2 prior appeals on this. The first appeal was reopened by Mr. McIntyre himself on a pro se basis. But again, we now know that this court, looking back retroactively, this court did not have jurisdiction to hear those appeals. And
well, that's certainly, we understand that that's your position. Fortunately, you've argued the merits in the event that we disagree with that position.
well, I'm hoping you do agree with my position.
No, I understand. That's why you're here, right?
Right, because the point of that is that there's no collateral estoppel, there's no res judicata that would apply to this appeal, and therefore he is not precluded from arguing all the issues in the case. And from my analysis, I feel there's some serious issues regarding the sufficiency of the evidence. There's some issues regarding inadmissible hearsay that should have never made its way into the trial. And so those 2 issues alone, the sufficiency, I think, would reverse his conviction with prejudice. And if the court if the court doesn't buy into that, at the very least, the inadmissible hearsay was material enough to warrant a new trial, because up until the point that Lieutenant Oldacre testified, none of the prior witnesses had implicated Mr. McIntyre in his purpose and his intent. And that's where the state's evidence is really lacking. And it wasn't until when Lieutenant Oldacre testified, he starts bringing in this hearsay evidence of the prior witnesses who had not testified to any such intent. He starts bringing in all this hearsay over Mr. McIntyre's counsel's objection. And the trial court itself had also asked questions that I feel were not appropriate and that were leading, suggestive, and solicited hearsay. So there are definitely some serious substantive problems, I think, with the underlying merits of this case, and I feel that those are available to be argued in this appeal, because when there was an undisposed charge, there was never a final appealable order, and the trial court had the authority to make that declaration under Vanderwright versus Vanderwright. That's an Ohio Supreme Court case from 1966. That's still good law today, and so the trial court had the right to look at its own orders and find that there was never a final appealable order. The state did not challenge that. The state, pretty much conceded that, especially when they moved to dismiss the remaining undisposed charge. The state acknowledged that the count 3 obstruction of justice had not been disposed. So for the state to try to change its position now, it's really disingenuous on the state's part. And so, because of that, we now know that this court never had jurisdiction to accept the appeal, and what's void is void. We don't look at, good faith, bad faith, or whose fault it was. We don't care about that. All we know is that, looking back, this court did not have jurisdiction, and what's void is void. And so, therefore, this is the first legal direct appeal from Mr. McIntyre, and therefore he should be able to argue all substantive issues. And if you look at it at a different angle too, there was an acquitted charge, the count 5 obstruction of justice, to which Judge McCarty had acquitted him on Rule 29, but that was sent to the jury for deliberations. He was then convicted on that in sentencing, and then that was also part of the mix on the prior appeals. So the whole process was corrupted by the fact that he had an acquitted charge in the mix of jury deliberations, of sentencing, and then appeal.
Well, there's a question regarding whether it was an acquitted charge, because there were 2 charges with the same.
Right, there were two obstruction of justice charges, but they pertained to different. Count 3 was obstruction of justice pertaining to a domestic violence case. Count 5 was obstruction of justice pertaining to a passing bad checks case. And in the transcript, in the trial, Judge McCarty had clearly explicitly stated that she was dismissing count 5, dismissing the obstruction of justice of passing bad checks. However, she ended up flip-flopping the 2 obstruction of justice charges, even though she made very clear she was dismissing the bad check obstruction of justice. But the bad check obstruction of justice got sent to the jury as part of the deliberations, and Mr. McIntyre was sentenced on that charge, and that charge was also part of this court's consideration on the prior appeals. Meanwhile, the obstruction of justice pertained to the domestic violence, nothing happened. It just floated out there in the wind. It never went back to the jury. It was never dismissed. It was just never disposed of. And so it was never substantively disposed of. And so therefore, because that was a remaining charge that was still pending, there could not have been a final appealable order, and this court could not have had jurisdiction to hear the prior appeal. And Judge McCarty acknowledged as much. I mean, she at least had the courage to acknowledge that it was a mistake. And so that mistake was corrected in July 2014 in a hearing, to where the state dismissed the obstruction of justice domestic violence charge, and the trial court recognized the acquittal of the obstruction of justice of passing bad checks. That left the 3 remaining charges, to which the hearing moved forward to sentencing. He had time served, and then as soon as the journal entry came out, this appeal is now pending here before this court. So
the state argues that your client did not file a transcript in this appeal, and you say that...
There are the transcripts.
Pardon me?
There are the transcript. It is in the record. What happened, Mr. McIntyre's uncle had went and purchased a transcript and then filed with the trial court, and that was part of the trial court record. And so therefore, when I filed this appeal and I'm checking through the document statement, there was no need for me to send a press key to the court reporter, because that transcript was already in the trial court record. So I just checked the box stating just send the record as is, because there were already transcripts from the prior, all the trial and all the prior hearings. Those were already in the record. The transcript of the July 18, 2014 hearing, that transcript was made part of the trial court record, I believe in August or September, I believe in August of 2014. So it is here. And I made 2 trips down here, checked the record twice next door. It is in there. So I think it's pretty evident to me the state of Ohio didn't bother to walk down the street and check the record and find that the transcript was in the record. And if they just would have done that, then they wouldn't have, I don't think the state would be saying what it said in its brief.
Well, it wasn't clear to me that the state was saying that there was no physical copy. I read their brief as attacking the propriety of the transcript. In other words, there was some irregularity about how it got there.
Yeah, what I later discovered after the state had filed its brief, and I made another trip to the Court of Appeals to check the record again, And when I discovered it was a copy of a transcript that was in the record. And so I believe, and Mr. McIntyre's uncle had the original, and it was later discovered that it was the clerk, the trial court clerk, made the mistake of not accepting the original, and instead they accepted a copy. So
that's what you're referencing that is in the record. Does not have the signature of the.
It does have a signature. There is a court reporter signature in there.
But it's not the original.
But then he did submit the original, and when he went to submit the original to the trial court clerk, they told him, "Well, go to the Court of Appeals clerk because the file's now here." So that's what he did and brought it here. So now this court has both the original and the copy. But the copy was already part of the trial court record coming up here, and so I was under the belief that when I submitted the docketing statement that transcript of the proceedings, the docket event, docket number 208, that there was no need for me to send a press copy to a court reporter and pay for a transcript when one was already paid for.
So that, when the state keeps saying that there's no transcript of the July 18, 2014 hearing, that's the transcript on the docket that's listed as filed on August 28, 2014?
Yes.
That's a transcript of proceedings, and that's a...
Yes, that is it. That is it. That's docket number 208. So...
no numbers anymore since it's all gone.
Oh, yeah, but August 20th, it was in the following month that I know that it was filed.
Okay.
And so I remember, Mr. McIntyre telling me that his uncle was going to purchase a transcript and he was going to, submit it to the trial court. And so the fact that the, clerk made a mistake in not taking the original instead of a copy, I mean, that should not be held against Mr. McIntyre. It is a true copy. It is a full copy, and there's no pages missing. It's got the court reporter signature on it. It tells you everything that happened in that hearing. So, and all the state had to do was just walk down the street, check the record. They would have seen it. They would have been able to read all about what happened on July 18th, but they didn't bother to do that. They just assumed that there's no transcript in the record because I didn't send out a press copy. So, and that's their fault, that's their mistake, and this court should not in any way bail them out of that. And, and therefore I think this appeal can move forward and evaluate the merits of what happened in the July 18, 2014 hearing, as well as evaluate all the merits of everything that's happened previously, from the very beginning. Because, like I said, I think this is the order that was filed on January 9, 2015 was the first time that there was any order in the trial court that disposed of all the charges in this case. That's the first time it's happened. It took 6 years, but that's the first time it happened. So therefore, this is the first appeal that functions after a full disposal of all the charges, and therefore this is the first direct appeal. And so therefore the issues of sufficiency, hearsay, the jury instructions, I mean, those should all be available to be litigated, and there's no collateral estoppel or res judicata that would apply.
And you have 2 minutes left. I just wanted to let you know so you could...
Okay, and I also just want to make a point about, in the July 18th hearing last year, there was an issue that came up about this case resulted in a parole violation on Mr. McIntyre's 1991 case, which we actually are contesting in the Supreme Court right now at the moment. So this all could get booted based on what the Supreme Court decides to do. But this case constituted a parole violation, and under the Kellogg consent decree, there has to be a conviction in order for a new offense to violate parole. And this court had decided in 1987 in State v. Dickens that a trial court can override the decisions of the Adult Parole Authority if they find that the APA decision is void, in which the APA had no jurisdiction. Judge McCarty in the hearing had found that the APA previously did not have jurisdiction to revoke Mr. McIntyre's parole because there was no final appealable order of conviction in this case. However, she refused to release him despite the fact he served all the time in this case, and she said, well, I'll keep him in jail for 7 days and see what the APA decides to do if they want to engage in new proceedings. Well, before that ever happened, aside from the fact that no order was ever filed in that 7 days, the Summit County Sheriff took him right back to the prison in Marion, Ohio, and that's where he's been ever since. And so there's definitely some irregularities that occurred, and that's also the subject of, he filed a pro se petition for writ of mandamus against Judge McCarty relating to that issue in this court, and that parallels this case. So the court needs to look at that as well. But overall, I think that all that would not matter as long as the court does what it's supposed to do in evaluating the sufficiency of the evidence and finding that the state never presented sufficient evidence of Mr. McIntyre's intent or his purpose regarding any of the alleged offenses, and therefore, on that basis alone, this case should be reversed, his conviction should be reversed, dismissed with prejudice, and that'll just effectively move all the other issues that we have before the court.
Well, thank you.
Thank you.
Out of time. We will take the matter under advisement and send you a written copy of the decision that is issued. You can always find it also on our website. Thank you.
Thank you.
Have a good day.